being president, who has done excellent work in quite difficult times. And also then welcome to Tony McDade, who has taken over from Stephanie, who's got to wear his very fancy medal for the first time at the opening of the legal year on last Monday. So thank you, Stephanie. Welcome, Tony. And then welcome to all of our guest speakers. We've got an array of speakers from all aspects of the judiciary. First up, you're going to hear from a district judge, Clare Hockney. She was admitted as a solicitor in 1995, and her first judicial appointment was that of a fee-paid judge in the first-tier tribunal, which involved, in that instance, social entitlement. She then moved up to the Special Educational Needs and Disability Tribunal, and then became a DJ in 2019. And she will be assisting particularly for those of you who are interested in DJ appointments or working in family law. Also online, we've got His Honour Judge Avik Mukherjee, known to one and all as Bick Mukherjee. 25 years as a criminal barrister. He became a recorder in 2009, and in 2015 was appointed full-time to Birmingham Crown Court, where he's been causing chaos ever since. Her Honour Judge Emma Kelly, the now designated civil judge for Birmingham. Again, a former barrister by training, she became a deputy district judge in 2010 and then a full-time DJ before getting that appointment in January 2021 as the designated civil judge based at the Birmingham County Court, which deals with civil and family, but her area of particular interest being civil. And then finally, save the best till last, Mrs. Justice Tipples, a fellow Gray's Inn member, called to the bar in 1991. Same as Bick, appointed recorder in 2009, but I think it's fair to say, Bick, that she's done somewhat better than you. Became a High Court judge and then was appointed full-time High Court judge in 2019. And now we are honoured and delighted that she is one of the presiding judges for the Midlands, and from a personal note has been so positive and enthusiastic in making sure that she gives tips and advice for all areas of career progression, and has been one of the most approachable presiding judges that we've had for a long time in the Midlands. So the purpose of today's event is really to try and help remove some of the mystifying aspects of the application process. Each of our speakers is going to talk about why it is that they became a judge, what it is that they enjoy about being a judge, and also give some tips as to how to get through the application process, because we know that good people are just falling at those hurdles. And we're going to try and run, I think, in the future, some more practical seminars to really assist people, whatever your background, to make sure that people are getting through that application process, because we do need more judges, both full-time and part-time at the moment. Once each of our speakers has done their part, we'll then invite a Q&A session. I think the best way that we will do that is to invite people to put questions, please, in the chat bar. And then I will try and moderate and come to each of you in turn. Hopefully that will take up the 90 minutes and we won't run over. But thank you, all of you, for joining on what I know has been a busy Monday for a lot of you, especially if you are ramping up to get back to work in the criminal bar. So without further ado, I'm going to ask Clare DJ Hockney to be our first speaker and just introduce herself and tell us a bit about herself and why one should consider becoming, at this aspect, a district judge. So Clare, over to you, and I'm going to mute myself, much to everyone else's delight.
Thank you very much. I come up as iPad. I think I'm supposed to change it to my name. I did try, but not very successfully, so I sort of failed on the IT front. But I've, as it said, I've been a district judge for 3 years, and exclusively in family, so just doing children work. And I did come from quite an unusual route. I'm a solicitor, there's less solicitors, I would say, in the court, certainly as you get higher up. I went to a state school, first one in my family to go to university, didn't go to Oxbridge, didn't have any network of colleagues at first. I soon developed those. Of anyone who ever had a judicial appointment, I made sure I kept in touch with them. So I came from, as I say, a very unusual route. And my background was, I was at the Equality and Human Rights Commission. So I was an in-house solicitor doing mainly appellant level cases. So I didn't have the day-to-day experience of being in court or of using of evidence or even swearing in witnesses. So I didn't have any experience really of that. But that didn't deter me from thinking, well, I want to become a judge. So when I was in my role at the Equality Commission, I thought, well, I want to do something more. I'd been in that role for 15 years, and I was really keen to be a judge. I don't really know why I wanted to be one, other than I thought I could do it. I thought it'd be fair. I thought it could be decisive, and I thought I could add something with my equality background. So even though I didn't have a lot of colleagues or other people that I knew that were already sitting as judges, I put myself forward for a fee paid role and started off in social entitlement, which again taught me lots and lots of skills, dealing with litigants in person, and dealing with those people that really it might be a small amount of money, but it's very, very significant for them. So it was quite a different court experience. And from that, I developed a whole portfolio of jobs. Up to at one point, I had, I think, 7 roles, not just in the judiciary. I had chairing roles, police roles, sitting on a panel for the NHS, and it enabled me to see a whole wide range of experience. And I would say for anyone, if they're applying now or thinking of applying, so if you are a first tier, you're thinking of going into the first tier tribunal as a judge or into the court, then don't be put off if you've not done anything of applying for both. Put in your application for both the tribunal and the courts, because it doesn't disadvantage you. It's the same form. It's quite a generic form, and it will really give you quite a variety of experience. If you do that, you might get all of the roles. You might get recorder, deputy district judge, and fee paid tribunal judge. I even heard of someone getting employment judge. But having those different roles gives you that variety of experience. But just in terms of me, I applied to be a salaried district judge, and I'd never been a deputy district judge. But I'm really glad I took something outside my comfort zone, because often I hear people saying, well, I do family now and I only want to apply to be a family judge. I'm not sure if that opportunity is available. If I'm a deputy district judge, I'm going to have to do everything. But I would say to someone, it's challenging. Get out of your comfort zone. It won't do you any harm to do that. You might have been a family practitioner for years. I wasn't one, had never done it, and now I've got into it. It's become my area, and I really enjoy it. So I would say, as a first tip, is for anyone is to don't think I'll only apply for what I know. I would apply outside, as long as you've got those judicial the skills, and it's the skills of decisiveness, of independence, fairness, treating people fairly when they come in. In terms of tips, in terms of for the application, I'm sure people will say about, you'll have heard this, that when you apply very much to be for your first position or for subsequent positions, you've got to have good examples. It's evidence-based. And I would urge anyone who's thinking of applying to speak to colleagues, speak to friends, speak to anyone you can find if you've managed to get a mentor about the process. That's really, really important. I was helped because I didn't know anyone, and then one of my friends got a fee paid position, and she really helped me, and I helped other people along the line, because that's what I think you need to do to get good people through. So there are mentoring opportunities. I would definitely urge you to go on any work shadowing schemes as well. They're very, very good. They're absolutely excellent, and they should be, I imagine, up and running now that we're out of the COVID time. I did judicial shadowing. I did a really good Law Society course, and that was aimed at, I think, women, those that might have not had a traditional background from the less traditional routes in. And I found that really, really helpful. We had a day going through questions, and my firm actually funded that because they were very supportive. So I'd urge anyone who's applying first time to do as many courses. As Michelle was saying, there's going to be courses run. I would go on. I would never give up the opportunity of help. So if someone offers it you, take it up, because it's going to be hugely beneficial to you. And in terms of actually, if you're perhaps a bit further along the process, as some of you may be, you may already be a deputy district judge, you may be a tribunal judge, you may be quite a number of judges at the moment. I would say when you're sitting or when you're in a workplace, write down good examples. Well, that was a really good example of when I dealt with a difficult person, when I had to use all my skills. It was a very difficult decision that I made, because when you come to do that form, although we all think, oh, I'm going to get the form ready, you often find you haven't. Then there's only a couple of weeks, then you're in a really busy case or trial. So get all that down, get it ready, and then you can easily fit it into your form when you get that. And when you do your form, I would say it's really important if you can find a friend, a colleague, someone who isn't applying, that can perhaps check through your form and say, does it meet the criteria to them? Do they understand it? I found that really helpful. People said, well, you know, you've just not met, you know, not sort of answered that question from what they could see. But in terms of a benefit of a judicial career, I had a huge benefit when I was what's called a portfolio judge. And I know they're not always popular, because I think it's seen that people have quite a lot of things. But when I was a judge with lots of roles and I still worked, I think it made me better in my day job. It made me a better solicitor. It made me better to better understand what the courts or tribunals were looking for. It made me better at my role when I was chairing meetings. I was a better listener. I was more decisive, more able to deal with conflicts at work. And I'd also say, although there's a lot of benefits from doing a portfolio career and having a lot of different judicial positions, if anyone is in that position that I was 3 years ago, they've got that flexibility, probably earning a little bit even more, and might think, I'm not going to apply for the district bench. I'm not going to apply to be a circuit judge or a district judge. I would certainly say there is huge benefits for applying for a salaried position from being fee paid. And I would encourage anyone who's sitting there, perhaps in the tribunal or perhaps as a deputy district judge, to think about that district judge position. Sometimes it gets a little bit of a bad press, but it's a fantastic and fascinating job. And once you are salaried, you have better work. If you're lucky enough to get to a big court like Birmingham, you can specialise in family work for those that do that. It's more challenging being salaried, I definitely say, but I've been able to take on being a family tutor. I'm editing the Equal Treatment Bench book. I'm editing now the district judge newsletter. Those are all things I wouldn't have been able to do if I was a fee paid or with this portfolio career. So it's been hugely beneficial in terms of my development. So I would certainly urge anyone who's thinking now in that position, I've got a lot of jobs, why apply? I really would apply. And you also have the opportunity to mentor, to appraise. And so again, you keep enhancing your skills and you have a network of colleagues. You're not just popping around to different jobs, different courts, different locations. You're actually going to be with people. So I would say sort of just really finally think about, from me, if you're coming from a solicitor background, it's sometimes, I think, harder to apply if you're not in and out of court all the time, but make those connections, do as many observations as you can, make as many connections as you can through the mentoring process, through the Law Society, through wherever you can get those connections, and don't be afraid to apply outside your comfort area. So if you're now a tribunal fee paid judge, don't think I could never be a district judge, because I've not done that, because I'd never done it. I had no experience of it, no family background, and I'd like to think I've made it a success, and I've more importantly, I've come to really enjoy it as a role and as a job. So that's all I'm going to say, because I know we've got lots of more eminent people to speak after me, but I hope that's helpful. Thank you.
That's really helpful. Thank you so much, Claire. And rather than taking questions for each speaker piecemeal, we're going to just do Q&A at the end for everyone. So thank you very much. We're going to move now to the opposite side of the spectrum, on criminal side, and come to you, Vic, also His Honour Judge Avik Mukherjee, I should say.
Thanks, Michelle. Hi, I too went to a state school in West Yorkshire, so not an area that was renowned for its legal community by any means. My parents came to the UK in the early 60s, and I found my way to do a law degree in Nottingham, and ended up joining Chambers in Nottingham. It was, and still is, a strictly criminal set, And so I'd made my bed from a very early stage that I was going to be a criminal barrister. And I stayed in those chambers until I was appointed in 2015. So I spent my whole career in the same chambers in the provinces. And I, in 2009, became Chamber's first homegrown recorder. So someone who'd gone from pupillage to recordership in Chambers, the first person to do so. I remember thinking about sitting as a judge and dismissed it initially. I thought to myself, I can't think of anything worse that I would rather do than sit as a judge. But with hindsight, I now realise that it's easy to say you don't want to do something because then you don't get rejected when you try and do it. And I suddenly saw my peers applying to be recorders. And there was, I have to admit, a feeling that maybe I was going to get left behind. And so this is probably around 15 years call, maybe a bit less. I asked why they were applying. And some gave me fairly anodyne, unhelpful answers. Others said it's what is expected. Not a great answer either. And so I thought, well, am I going to apply because I feel pressure from my peers, or is there something more to this? And I think by the time I got to 15 years call, I realized that I need to develop professionally and challenge myself to prevent myself becoming stale and, dare I say, bored. And so I did apply, and then applied again after I got knocked back first time, and then applied for a third time when I got knocked back second time. And my message from that is that it is competitive, but you have to figure out what the JAC is looking for. And if you want something badly enough, work hard, be determined, deal with rejection. We've all had to deal with that in our professional lives at some point, and eventually you'll get there. I was then appointed as a recorder, as Michelle said, in 2009, and within a very short period of time, I realised that it galvanised me. It made me excited to go to work again, something that I hadn't felt for maybe a couple of years. Maybe the load of a senior junior was getting to me. And I also found that it increased my interest in criminal law again. It was a different perspective, but within the same system, which appealed to me. And in fact, I think on reflection, allowed me to be myself more than playing the role of an advocate. And dare I say it, I think I'm probably a better judge than I was a barrister. And some of you are probably thinking, how bad a barrister was he if he's better as a judge than he was as a barrister? But I feel it draws on my strengths, and I don't have to fake it anymore. So I realized, having sat for about 3 years, that actually this was something that I wanted to take further and wanted to do full time. And I think you get to a point as a barrister where you've got to decide between silk and a judicial career. And I had decided through the experience of sitting as a recorder that it was a judicial career for me more than anything else. So I started the process of applying to be a CJ. I got an interview first time, which shocked me. And I think it shocked me so much that I didn't prepare for the interview. What a fatal mistake that was, because I can say with some confidence that that first interview was a complete car crash. And needless to say, and with justification, I wasn't appointed. Please don't go into any interview or any of these processes, if you choose to, being underprepared. And so I applied the following year, and I prepared myself, and I redid my form, and I thought this was a better form than it was the year before. But I didn't get an interview in that second year. So, you know, you start to doubt yourself. Is this for me? Can I cope with being knocked back this many times? It was only 2, to be honest, so it wasn't that many times, but it takes its toll. And sometimes it's easier to say, well, I'm not going to apply again. And then you don't have to deal with the rejection. Of course, if you don't apply again, you don't know whether the next time is your time. And so I decided that I would, as Clare has already mentioned, I would seek out a mentor, and the Bar Council and the Judicial Office were opening themselves up to mentor and mentee relationships. And I was very lucky that I got a mentor who at that time was a very senior judge, now a High Court judge. And he didn't write my form for me, of course he didn't, but he was fairly liberal with his red pen when he asked to look at my examples. And I found that as an invaluable lesson, that you may think that something is a good example, and it may be a good example, but if you've been at it for many, many years, as we all have, there will be even better examples out there that you have lived and breathed. But as Clare was saying, the passage of time dilutes the impact of them, and that's why it's really important to make a note of those examples when the cases are occurring. We've all had those cases where we've come away from them saying that was an absolute nightmare, and indeed it was. And that's the time, as painful as it is, where you take a note of what made it a nightmare, because then you're not scrambling around in the back of your memory months, even a year, 2 years later, to remember that sort of detail. And I have to say, if you go onto the JAC website, they will spell out exactly what they want from you. It is, as Clare said, all evidence-based. So, for example, no one's ever doubted my integrity is not a good example that demonstrates your integrity. And if you go onto the website, they will show you what the competencies are, and indeed the sub-competencies within each of them. And it's upon that that you, as I did, must frame your examples. And I ended up having a spreadsheet that set out the competencies, and then 3 or 4 examples for each, which I played with as the application process started to pick out the choice examples. So I would definitely do that. And the thing about these forms is the greater practice that you have, the better. So even if you might be sitting there thinking, well, maybe I'll leave it for another year, don't. Start filling out these application forms now, because it's all good practice. And you might end up finding that you've been shortlisted in one of the competitions. Again, I agree with Clare. Shadowing is invaluable, and you as practitioners are probably in the best position to be able to access people that you can shadow or ask someone to formally or informally mentor you. There's more than one way to skin a cat. I assumed as a criminal barrister that the route into judicial office was to become a recorder, and maybe it was back then, but that's certainly not the case now. So look around at these other judicial roles, whether they're tribunals or not just recorder level, because it's all good experience. It will enhance your application form, and you'll probably find that you really enjoy it. I'd also encourage leadership roles. If there's anything that you can take on within your work environment, or even on an extracurricular basis. For example, if you're a governor of a school or you coach a sports team. These are all qualities that will feed into those competencies that the JAC is looking for. There's also a scheme, I don't know how many of you have heard about it, called the Pre-Application Judicial Education Scheme, PAGE, it's called PAJE. And that's run by, amongst others, the Judicial Office. And it's a number of workshops that are set for applicants. There's an application process, inevitably, but it will give you insight into what it's like to put yourself in the position of a judge. And also one of the final workshop is someone from the JAC who will come and speak to you to advise you on the application process. I would thoroughly recommend Judicial Office to anyone. I find it incredibly rewarding. I find, despite the fact that I'm an employed civil servant, greater autonomy than I ever had as a self-employed barrister. It suits my personality, and there's an obvious need for diversity in the judiciary, and maybe at some level I felt that I had an obligation to take up judicial post, as well as enjoying it and enhancing my interest in the criminal law. It is all merit-based, you'll be delighted to hear. The days of a tap on the shoulder have well and truly gone, and thankfully they have, because if I was relying upon the tap on the shoulder, then Michelle wouldn't be asking me to speak to you. She probably wouldn't know who I was. So it's all merit-based, thankfully, which increases everyone's opportunity. Applying is success, okay? So don't look at rejection as being unsuccessful. The fact that you apply is success within itself, but being appointed is obviously the icing on the cake. You need to apply for yourself. We need you to apply, because we need the next generation to come through. But please be resilient, show determination, work hard, get guidance and help from others. There are many, many people out there who will be able to help you through this process. And I'm fairly sure that you'll end up enjoying it as much as I do. Thanks, Michelle.
That's great. Thank you so much, Vic. We're going to come now to Her Honour Judge Emma Kelly, who, as I said already, is the designated civil judge for Birmingham. So thank you. I'll hand over now.
Thank you, Michelle. Although I'm now the designated civil judge for Birmingham, I have experience of a variety of different judicial roles. I was appointed as a deputy district judge in 2010, and thereafter a salaried district judge in 2015, and a criminal recorder in 2018, and then was ticketed into civil. I initially applied in 2009 to be a deputy district judge, and then was appointed at the end of that competition in 2010. I applied because I had friends and family who already sat as various different judges, and I knew they enjoyed it and found it very rewarding. And I took the view at that time I wanted another challenge alongside my work at the bar. At that time, there were no civil-only recorder competitions being run, and I didn't have the confidence to apply to sit in family or crime at a time when I had no experience in those fields. So a civil deputy district judge appointment seemed the obvious entry point into the judicial profession. I have to say, it didn't occur to me at that time to apply for a tribunal role. Things have changed significantly, and Clare's story in itself demonstrates how easy it is to, once you have tribunal appointments, to transfer across into the court judiciary. I enjoyed sitting as a fee-paid judge. I quickly decided that I wanted to take a salaried appointment. At that time, I could see the benefit from a work-life balance point of view of becoming a salaried judge. My husband at that time was already a salaried judge. I could see the amount of holiday that he got, the fact that it got to weekends, and he was able to switch off far more readily from work than I was. And I spent a number of years of weekends and holidays when I should have been taking a break from work, instead dealing with emails and calls from clerks and solicitors in relation to my practice at the bar. So that was instrumental at the time, particularly because when I became a salaried judge, my children were only 4 and 7. And I found that I did have a better work-life balance. I was able to work a 90% salaried part-time working contract when I was first appointed. But what I would say is, in making any application, apply on your own terms. I put in an application to be a salaried district judge in circumstances where I was very happy at the bar. I was busier than I wanted to be. And I made up my own mind that I was only prepared to accept a DJ appointment if the package was based primarily in Birmingham, because I wanted access to the Queen's Bench and Chancery work that I knew would be available in Birmingham but would not be available at a smaller court centre. And I knew that I wasn't prepared to relocate and couldn't, quite frankly, have relocated to accept an appointment. So apply on your own terms. There's nothing wrong with that. People recognise that it's not easy these days to up sticks and move, not least because the salary often will be less than that which you've been earning in private practice, and certainly isn't such that I would have been happy, for example, to relocate to the southeast. I very much enjoyed being a district judge. I had access to a huge jurisdiction. I was a specialist chancery and then business and property courts district judge. And I reached the point where I wanted access to more trial work, and therefore applying to be a recorder seemed the next obvious step, while still keeping control of geographically where I would be working. And that remained very important to me. I wanted to be spending most of my time at or close to Birmingham. And by being a recorder, I still had that control. Again, I made a tactical decision to apply to be a criminal recorder rather than ticking the box for family. It was only a crime or family competition. I didn't want to be a family recorder because I didn't want to be public law ticketed, because I didn't want to undertake public law work as a district judge. I thoroughly enjoyed sitting in crime. It was a completely new challenge to me, but I enjoyed the Crown Court jurisdiction, albeit I took the view that I didn't want to undertake criminal work on a permanent basis. The next obvious step for me was to apply in circuit judge competition. I did apply in circuit judge competition for a civil only post. Whilst that competition was ongoing, the DCJ competition opened, and I was encouraged by colleagues to apply for the DCJ role. And then when I was successful in that competition, I withdrew from the civil circuit judge competition. I recognise that district judge to senior circuit judge is not the most obvious of career paths, but I'm glad that I was persuaded by colleagues to apply. There are many benefits to taking a salaried post. A fee paid role as an introduction to the judiciary is all well and good, and I had the most fantastic time being a fee paid judge. But there are real benefits to taking a salaried role. At whatever level you're sitting as a salaried judge, you will have access to more complex work than the fee paid judges do. Particularly if you're sitting in a larger court centre. At district judge level, there's the opportunity in Birmingham to be ticketed to do specialist personal injury and clinical negligence work, to do Equality Act work, to undertake business and property courts work, to name but a few. At circuit judge level, the civil circuit judges have the opportunity to undertake the longer and more complex county court trial work. They only undertake the county court appeal work. Fee paid judges do not do that. And there are opportunities for further career advancement by way of application for Section 9 tickets to sit in the High Court. As Clare Hockney's already mentioned, there are multiple opportunities as a salaried judge to undertake mentoring roles, appraising roles, becoming involved in the Association of District Judges or the Council of Circuit Judges, becoming involved in the Judicial College, the Civil Justice Council. Those opportunities are not readily available to those who have fee-paid only appointments. Whether a fee-paid or salaried judge, I have found the working environment to be incredibly collegiate, both between judicial colleagues, but also the staff. Most judges find that they establish very good friendships, let alone working relationships with their colleagues. There is obvious career progression through the judiciary, far more so than there was even a relatively short time ago. I can demonstrate that myself, and there are many others on the circuit bench who started off in tribunal or district bench roles. The judiciary now is more flexible, in my view, in terms of salaried part-time working opportunities. When I initially applied for a salaried post, it was a push to be persuaded, to persuade the delivery director to accept a 90% salaried part-time working role. There are now a number of judges working similar packages, and if that is something that fits in with your lifestyle at a particular point in your life, that's something that will be considered subject to the business need. The application process is undoubtedly daunting, not least because of the length of time that it takes, and the uncertainty of the outcome. There is, however, real support on hand. If you're already a fee-paid judge, you will have a mentor judge. Lean on that mentor judge to provide you with support. If you're not already a fee-paid judge, many salaried judges are willing to mentor and support prospective candidates on an informal, confidential basis. There are official work shadowing schemes. In Birmingham, we've been fairly flexible in supporting candidates who want to come and do a day's sitting in to have that opportunity. And if there are applicants who are contemplating district bench or circuit bench applications and are interested in sitting in civil or family, I'm perfectly happy to be contacted, as I know is Her Honour Judge Sybil Thomas, the designated family judge, and we'll organise opportunities for people to undertake some sitting in and speak to salaried judges if you would like some support. A number of the other speakers have already referenced the application form. I want to re-emphasise just how important it is that you use good examples in that application form. The JAC have produced a really useful guide called Preparing for Judicial Selection Exercises. It's hidden away on their website. I don't find their website the easiest to navigate, but I can certainly forward a copy to Michelle, who perhaps can circulate it to those that have attended tonight, because it's a really good guide to how to approach the completion of the application form and the other aspects of the application process. Don't leave it to the last minute. The competency application form requires a considerable amount of thought. It is sensible to run it past somebody who already has experience of the process and get their view on whether you are ticking the competencies. It's much easier to keep a log of examples as you go along, rather than trying to think back to find a suitable example at the last minute. A number of the fee-paid competitions now do not require you to complete the application form until you've passed through several stages of initial testing. So don't be put off putting in an application in, for example, the Deputy District Judge or Recorder competition by thinking you've got to complete the application form up front. You don't. It's only when you progress to the point just before selection day that they require the application form to undertake the sift. The other thing I would advise is thinking very carefully about who you ask to be your independent assessor. You usually need 2 independent assessors for the competitions. It needs to be someone who knows your work really well, because the assessor form is virtually identical to the candidate application form, and the assessor therefore needs to be able to provide evidence-based examples against the 5 heads of competency. I've had a lot of experience, particularly over the last 2 months, of completing assessor forms for a variety of competitions for candidates. It's a hugely time-consuming task for the assessor if they're going to do it properly. So you need to make sure you've got confidence in the person that you're asking to do that. I would usually ask any candidate that wants me to provide an assessment form for a copy of their form so I can see what they've said, for copies of any written judgments or approved transcripts if they're already a judge, or if they're in practice, details of any cases in which they've appeared in front of me, and copies of any written work that they can provide me with to assist in the process. As Vic has already said, do not be put off if you do not get through. The JSC process is somewhat arbitrary. There are examples of plenty of good candidates who have not got through the initial rounds of testing, or who have not got through the SIFT 1 year, only to get through the next year on exactly the same application form. So you do need to persevere and be fairly resilient as to the process. Before I finish, I'm just going to give a quick plug for the DDJ competition. I looked on the Judicial College website earlier this afternoon. There is a DDJ competition open at the moment. It closes at 1 o'clock tomorrow lunchtime. Because it's a fee-paid competition, you do not need to complete that competency application form by 1 p.m. tomorrow. All you need to do is simply register for the first stage qualifying test, which is a situational judgment and critical analysis multiple choice test online. So it's very easy to register, and if you're thinking of an entry point application, Deputy District Judge is a very good way of accessing a fee-paid court judicial post. But the JSC tend to run DDJ, recorder, district judge, circuit judge competitions every year. But you do need to start thinking in advance before the competitions actually open. I'm going to leave it there, and before I hand over to Amanda, who will give us her insight from the High Court bench.
That's fantastic. Thank you so much, Emma. Again, really useful and practical tips there. So last and absolutely no means least, I hand over now to Mrs. Justice Tipples. Thank you for joining us.
Well, thank you to the Midland Circuit and also to the Birmingham Law Society for organising this evening's event, which I'm sure is of great value to all of those of you who are listening in, and for inviting me to speak. The way I thought I'd approach this was to identify the benefits of a judicial career, speak about how I became a judge, share some of my tips on the application process, although most of them have been identified by others already this evening, and then make some final observations. So what is it to be a judge, and what is it that judges value about a judicial career? Well, before I tell you my thoughts, I just want to share with you some of the views of the judges on your circuit, because today I've been on a court visit to Stafford Crown Court, and I've spoken to the judges there, and I told them about this evening's event and that I would be speaking, and I asked them what they would say about why it is they like being judges. The first point they all identified was having a new career. And in the case of the judges at Stafford, they've all come from a previous career at the bar. And having spent many years in practice at the bar, they found it very refreshing to have a new career. They all welcomed the change and the new opportunities presented by a different career, and a career which was only open to them by dint of many years in practice in the legal profession. And that's an opportunity which is not open to many of their friends or our friends in other walks of life. Second, they really valued collegiality and the collegiality of life on the bench. Many practitioners at the bar, and no doubt also from work in solicitors' firms, are frightened that it will be lonely when they leave life behind in the robing room, and you're parted from your colleagues in chambers or from your colleagues at your solicitor's firm. However, courts are very friendly places, and it's an incredibly collegiate environment, and judges are very supportive of each other and as are the court staff. Judges make new friends and you're not on your own. Indeed, for many, post-pandemic life in chambers, no doubt life in solicitors' firms, is not what it was before March 2020. But judges come to work, support each other, and the judges' dining room in most court centres is very well attended and very lively. Third, practitioners are concerned that they will miss the advocacy. Well, it's true, you will not be cross-examining witnesses any longer, but you still have to think very hard about what you say and how you say it. For example, thinking about how you speak to and address a jury. Sometimes there are quite difficult issues. You want to tell the jury what is or isn't going on, but it may be you can't tell them everything. Yet you have to think carefully what you say to them in terms of how you take them with you and get them to understand what it is or isn't happening, and then explain the unexpected things which happen in a criminal trial. That's can be and is a real skill. It's communication. Again, it's not cross-examination, but sometimes there are quite difficult things we as judges have to say, and how we say them really matters. Fourthly, Emma's touched on this, the time for holidays is very, very generous. Many judges, when they've been in private practice, have really taken very little holiday and limited the amount of time they've had to themselves. You do get generous holidays, and that's a real advantage of salaried working in terms of what that provides. And lastly, there's considerable flexibility. Again, Emma's touched on salaried part-time working, that's something which is open when the business need meets it, but it's something which many judges work on salaried part-time working. And if you have family commitments, that does work very well for people. But also when stuff happens, whether it's in terms of illness, health-related issues and so on, there is flexibility. And as an employee, that works well for many people, which takes the weight off their shoulders in terms of the role that they have. So that is what all the judges in Stafford today told me in terms of things they really benefit from in terms of their role as judges. And I expect if I asked the views of other judges at different court centres on circuit, the views would be very similar, if not the same. As for my own views as to a judicial career, the way I see it is that it is hugely refreshing to have a new job in your 50s. I love my career at the bar, but I was ready for change, and I don't for one moment miss dealing with clients or my self-employed life as a barrister. Secondly, it is so much more collegiate than I expected. I have fantastic colleagues, none of whom I really knew before I started as a judge, and they're very supportive, and I formed very strong friendships already. Also, it's enormously interesting in terms of the variety of work and the people that you work with. This is particularly so because the cases are finite. You have a case, you make a decision, you give a ruling, you sum up, or you sentence, and you move on to the next case. Of course, you take all the time you need in making those decisions, rulings, summings up, and sentences. But when they're done and you've made the decision, you move on. It's not like at the bar, which where I was in practice, and you have a case and you get it up once, and you may have to get it up again and do the appeal and so on and so forth. So that's one way of looking at it. And you have a constantly varied and interesting diet of work. And the variety is simply inherent in the work that you do. The flip side of that is that you're never alone. If the parties are represented, of course, you have counsel or solicitor advocates in front of you to assist you with finding the answers. But also you have your judicial colleagues who you can bounce points off if they're particularly difficult. It's your decision, of course, but there is plenty of support. So for me, I think it is a fantastic job. I enjoy it enormously, and it's something that I've wanted to do for some time. In terms of my journey as to how I got here in terms of becoming a full-time judge, I was in practice in a chancery commercial set of chambers in Lincoln's Inn. My work was trust, company, insolvency, partnerships. It was litigation, so I was a litigator. And in the early 2000s, I became one of the counsel on the Attorney General's panel. I was on the B panel and the A panel. And that stood me in very good stead in terms of my career, because for those of you or any of you who've been on the Attorney General's panel, the work is incredibly varied. And when you're on the panel, you're deemed able to do it. So the fact you've never done it before doesn't matter. So it gives you experience in doing a whole range of work. And so if any members, junior members of the bar are listening in, then applying for the panel is a very good thing to think about in terms of variety, because one of the skills of a judge is adaptability and be able to turn your hand to different things and not being afraid to do so. And that was an area where I think my getting that role was a key aspect in terms of where I have ended up, as it were. But I was in my chambers, a lot of the senior silks were in those days assistant recorders. So these were silks doing chancery commercial work, and they sat in the Crown Court. And in those days, we had a chambers tea at 4 o'clock every day, or 4:15 after court. Actually, it was probably 4:30 actually. And the people would come back from their days in the Crown Court, and either at tea or later in the evening would talk about what they were doing. And I thought, and they all loved it and they found it incredibly interesting. And I thought, that's what I want to do. When I grow up and I become more senior, I want to sit as a recorder. And that's what I applied to do in 2009. So I wasn't a silk. I've been in practice 17 years, and I applied to be a recorder and got through the competition. And I then started sitting in, first of all, Guildford Crown Court and then St Albans Crown Court. And I absolutely loved it. And I also worked with incredibly supportive judges. They didn't mind the fact that I come from a civil background. And in fact, they used to think it was marvelous because they could list all the proceeds of crime hearings in front of me because I might know something about trusts. And but they always settled, so it was never that bad. But I received a lot of support from my colleagues at St Albans, and I used to sit 6 weeks a year there, and I sat there so much because I enjoyed it. And of course, I was very conscious that I hadn't had experience in the Crown Court before I became a recorder, and I knew that the more I did, the more I'd learn. And that's why, and I did, I really enjoyed it. And that's where I started off. I became ticketed to sit as a Deputy High Court judge in the Chancery Division in 2013 and started sitting there. And what was interesting about that was sometimes I got cases which I could see that there may be something complex. But again, I always took my time on my judgments, because when you've heard this evening about getting evidence in terms of when one makes applications, the key thing about it, about judging, and what I learned was that you never assume anything and always ask counsel if you need help. But secondly, take your time over judges, over judgments and rulings. Nobody is sitting there thinking, oh, that misrecorder Tipples, she spent ages on that. It's much more important to take your time. And again, when I started sitting in the High Court, I took my time on my rulings, because they're very, obviously, decisions are very public, but it's important to do work that you're comfortable with, and then eventually you'll hand down your judgments. About the same time after that, I became involved in the Chancery Bar Association, and that was also at a time when my mother was unwell, and I was very cautious about what was going to happen, how much work I'd be able to do. But I decided to get involved with that, and that turned out to be also a good decision from a career perspective, because it immersed me in leadership activities and also working with people from throughout the profession, and also balancing taking her to hospital appointments and so on. It was an easy thing to do, whereas running a litigation practice wasn't. I continued working at the bar, but I certainly wasn't working as hard as I'd done 5 years earlier. But what I didn't realize at the time was actually that Chancery Bar activity, and in the same way, whether you get involved in your law society or the circuit, exposes you to a different range of experiences. And Vic has picked up on this evening in terms of leadership. It gave me experience, which now I look back on and I regard as invaluable in terms of the role I now have, because you're just doing different things. And that is a really valuable experience to have. And when I was vice chairman there for 2 years, I was on the Bar Council. I was involved in a number of different aspects of it, and involved working with different people, but also taking on issues which weren't necessarily popular. But again, that involved skills which now I regard as having developed then, and which I think are very useful. And by 2018, I decided I wanted to be a full-time judge, and I applied in the High Court judge competition then, and I applied to be both a Chancery judge and a Queen's Bench judge in both competitions. But on speaking to, and we've heard about mentors and colleagues from my chambers, 2 of them became High Court judges in the Queen's Bench division. One was Sir Richard McComb, the other was Sir Nigel Davis. And before I was interviewed, I wanted to know what the day job of a High Court judge really involved, and particularly whether in the Queen's Bench or the Chancery division. And what I realised was if I became a judge in the Chancery division, I would never be sitting in crime again. And for me, my passion was to sit in the Crown Court. So I withdrew my application for the Chancery division and applied to become a judge in the Queen's Bench division, so I would be able to do Crown Court work. And that's what I really, really enjoy, because as a judge, the variety of people that you're working with in the Crown Court is extraordinary, but it's a huge privilege to be working in that environment. And I was fortunate enough to get through that competition and started in 2019. And for me, that was the best career decision I ever made. But if you look back on it, I think what my own story tells is the ability to be adaptable and also to throw yourself into different aspects of professional life. Because being a barrister is one thing, but the amount you learn by involving yourself in other activities, both within the profession and outside, is actually critical. And because of what you learn and what you expose yourself to, and experience is all, because if you get experience, you get confidence, and that leads you on to different things. In terms of tips about applications, I think the first point is be realistic in relation to the experience that you have and what you can aim for. Many people look at judicial roles quite early on, and that's entirely sensible. But there's a huge amount of information on the JAC website, as Emma's identified. But look at that, but think there's not just whether it's, I wrote a reference for a junior practitioner in relation to applying to be an adjudicator in, I think, congestion charge or parking disputes. But when I'm saying that, it's that if you're realistic about your experience and what you want, what skills you have, is that ultimately these evidence-based applications are looking at your ability to make decisions. So what experience do you have of decision makings? And if you're interested in becoming a judge, getting evidence of that, you may have it from being on boards, being a trustee, being a school governor, whatever. But there are very interesting judicial roles which are there, and look at those. But look at your own experience, what stage you're at, think about that, and look at the information on the website. The second point, others have touched on this, keep a note of what you've been doing. That's also really important, because as you've heard, these forms to fill in are challenging in terms of putting the evidence together. Of course, they take time and they take effort and they take energy, but do keep a note of what you have been doing, and that can be used as an aid memoir in terms of what it is that you have to rely on in terms of evidence. Do take the opportunities to talk to people. Emma's given a very generous offer this evening in terms of making contact with her if you're interested, but also from your own colleagues in your law firm or in chambers, and take opportunities of mentoring, work shadowing. Others have talked about that. They're quite right to do so. They're completely invaluable in terms of resources. But also understanding what it is to be a judge. Some people may find it something actually they wouldn't enjoy or they might not like. But starting off as a fee-paid judge for many is very interesting. And I think Claire mentioned this. It actually takes a lot back to your own practice in terms of ways are presented. I know myself, I certainly was a better advocate when I became a recorder, because I saw how things were done very well, and perhaps not so well in the courts where I was sitting. The next point is keep going. You've heard stories from others. Bick has very powerfully explained his own story this evening, which is one of resilience and dusting himself off and keeping going. And many judges would actually give you a similar story. In fact, applications get stronger over time because you have more evidence and more experience. So do not be discouraged if you don't get through a process first time round. You are in extremely good company. It is not, whether it's on the High Court bench, there are lots of stories of people who have not got through and get through a second time, third time, fourth time round. So if it's what you want to do, stick with it. Your form gets better, and so on and so forth. And as Bick said, do get, and Emma's also said, do get somebody else to look at your form, whether it's a colleague in chambers, a partner, or a professional consultant, however you approach it, because one of the things a lot of people overlook is on the JAC selection panel, it's not just lawyers, there are lay people who are the majority on these panels, and you've got to communicate to them why it is you have the skills and abilities. And what you say on your form, my forms have always been read by others before they've been submitted. So why are you saying that? What does that mean? And to lawyers, it may be familiar, but you've got to communicate to everybody on that panel why it is that you have the skills. The referees are also very important. Emma's made that point. You need people who know your work and who know you. If you are a recorder and you're thinking for appointment of a circuit judge or a deputy district judge, there are appraisal schemes there. Those appraisal schemes are very well established through the DDJs, and that will one means of getting evidence. On the recorders, a lot of that's been paused on circuits of the pandemic, and we're getting that up and running again. But appraisals are a very good way for getting evidence and using that as well. But your referees are really important, and people who know you best. So it is not the most senior person in your chambers, it's somebody in your law firm. It's those who actually know your work, and it's the evidence that they can give, which is really important. And Emma also said, do contact your assessors and ask them whether they're happy to give an assessment for you. A, because if they don't think they've got the evidence, they'll tell you. B, they are time consuming. That's not a bad thing to bear in mind. But as Emma's done, I've written assessments for a lot of people, but they can take half a day or a day to write. Because if it's somebody who has got the evidence and you want to give them a good reference, it takes a long time to put that together. So that's judges' time, and I'm always delighted to do it, but you just need to know that it is something which we do spend time on, and it's always best to know it's coming down the tracks as opposed to getting something out of the blue. I think if I say anything else, I'm going to be repeating what others say, but I'm very happy to answer questions, and I'm also always happy to speak to people if I can do anything to assist.
That's fantastic. Thank you so much to all of our four speakers. I think we all agree some really useful practical tips there, and also offers of assistance, which really exemplifies again the strength of the collegiate atmosphere between both the Law Society and the circuit. So I'm going to open up the floor now to questions. Can I invite anyone who has a question, please indicate in the side chat bar, rather than just trying to speak. That way we can try and moderate it. At the moment, there's a stunning silence, which means that our speakers have been so wonderful. They've actually answered every question that everyone has had. If anyone does have any questions, please put them in now. But what I would say is that I think most people worry about the scenario whereby the practical exercise part of the application process, where they're given a case as if they are the judge, and then they have to react to the situation that is thrown in. My top tip for that would be to be yourself. And this is what can be expected at selection days. There's two parts for the recorder selection day. The first part is one part is an interview with both a a judge, and then also a non-legal person. So you have to be able to explain your role and your competencies in a way that a non-lawyer can understand them. And the second part is a practical exercise whereby they put you in a fake courtroom, give you a scenario, usually with litigants in person. So what you need to think about is communicating with people who are not lawyers. So when you are explaining a judgment that you are giving, you've got to make sure you are giving a proper judgment, but in language that is able, you're able to communicate it well, that you are approachable as a person, you deal with these litigants in person. And that for me is one of the things that people worry about the most. But that's what I found for the selection day. I can only speak from that. I don't know what the other jurisdictions have for selection days. If anyone else of our other speakers wants to jump in at this point.
Well, can I just say this, is that before a selection day, you'll get information in relation to preparing for it. But two things. One is on your form, you will have given examples of evidence to support the skills. One thing is you'll need to think about updating those. So your form will have been submitted and it'll be some time for your selection day. So you need to work on your examples so that when you are asked to provide more evidence of the examples, you're not just looking at your form, you'll be able to have additional material. That's one thing. Yeah. The other thing is, in terms of preparing for the scenario, we're fortunate to have one of our speakers is Clare Hockney, who is the editor of the Equal Treatment Bench Book. The Equal Treatment Bench Book is the incredibly valuable resource of information, which is very helpful. And I would recommend anybody who's preparing for selection day to have looked through that and read it. Got a lot of information on dealing with, for example, unrepresented parties, but also all sorts of different issues. It's just a complete mine of information. And familiarize yourself with that, because you'll find that hugely helpful in terms of preparing for a selection day. That will be something I would direct your attention to.
Thank you. Another question we've had is that I need specific tips for the qualification test for DDJ roles. Claire, is that something that you can help with?
Well, I never did the test to be a deputy DJ, but what I would say, I did plenty of tests for the tribunal, and I would say that, again, as has been said, read the Equal Treatment Bench Book. You can't read all of it, but the tips about dealing with litigants in person, difficult people, it's really helpful. Read the materials they give you and remember to go back to basics. And I think that's why I think I did quite well in the situational questioning, surprisingly, for the district judge competition, because I knew nothing. So I did look at it all I looked at what I was given, read around, and I gave quite a sort of basic but moving on answer. Whereas I think very experienced people who've been doing it for 20 years as a family practitioner, perhaps just jump in, forgetting very much the basics because they're so familiar with them. So I would say always remember the basics, look at, if it's a tribunal, whatever, wherever it is, if it's a court, look at the overriding objective, make sure you look at the practice directional rules, whatever it is that the question's answering, you go back very much, it's a bit like driving. When you first start driving, you should do everything right. But you often forget that after a while, your hands cross over. So you've just got to, I would say, definitely a tip, and don't give up. Loads of people don't get through. It's not embarrassing, but prepare for it.
Thank you.
The test.
Question from Eileen. Is it better to apply to a role where you have some experience, albeit limited? If no experience is required, how are you trained in that area of legal expertise? For recorders, you have a week-long training course. So in crime or family, whichever area, you have a week-long, and it's literally a crash course and bombarded with information. I don't know how that works for the other areas. Emma, are you able to assist in that?
It's similar in the other jurisdictions. The advantage of the recorder competition is that it's non-jurisdictional as you go through the assessment process. So the fee-paid competitions, the DDJ and recorder, will have a selection day with a role play scenario and then a competency-based interview. The salaried positions, so the DJ and CJ, will have an initial sift. Then if you get through to the selection day, instead of being role play, there'll be situational questioning and a competency interview. But for those non-jurisdictional competitions, the selection day, for example, will be a series of usually made up rules, and you have to apply those made up rules to the particular factual scenario that you're dealt with. So the fact that you don't have a background in civil or family or crime doesn't matter. It's then when you're appointed into a particular jurisdiction. There's been lots of examples of people being appointed into jurisdictions in which they don't practice. I was appointed in crime, and there are similar family, civil, and crime usually week-long induction courses for new appointees, and then there'll be periods of sitting in with an experienced judge, usually before that course and several days after that course. And then when you first start sitting on your own, you'll have a supervised week with a supervising judge to oversee you during those initial days. So the fact that you don't come from that jurisdiction absolutely isn't a bar. You will receive the appropriate training. We want people to be properly trained before they're sitting in the jurisdiction.
Brilliant, thank you. Next question: is there any benefit in seeking the assistance of a consultant with the process? Did any of our speakers use a consultant to assist them?
Well, I can answer that to start off with, is that when I used a consultant when I applied to be a recorder, and every judicial application I made, I used a consultant. Now, in terms of that process, the reason I did so was because making an application is a hugely time-consuming process, and I took the view of I was in for a penny, I was in for a pound, and I found it actually helpful, perhaps less so when I got to the High Court application, but when I applied to be a recorder, I used a consultant for the interview. I didn't use it for filling the form. This is in 2009. The interview, I hadn't had an interview for at that stage 20 years, and my only recollection of interviews, I didn't think they'd ever gone very well. So I didn't think I'd ever really succeeded in an interview in terms of whether I didn't get tenancy or or so on and so forth. But anyway, I did use it for that. And of course, the interview process is very different to what it was 20 years ago when I was being quizzed on my legal knowledge. Rather, the interview is a process of getting you to identify the evidence in support of the application. And the benefit of a consultant is essentially that person is helping you get that evidence out. So I mentioned earlier about updating your examples. So when you get to a JAC interview, they're looking to get the best out of you. They want to get the evidence out of you to support the application, because if you're going to be recommended for appointment, it's got to be justified by dint of the evidence. So when you're asked to give an example about dealing with a particularly difficult person, you've just got to think, that's my example, and explain it. And what it's doing is actually giving you the confidence to get that out so that you know what you're going to do. So I found it very helpful, and I'm pretty sure it made a difference in the application. And again, when I applied for Silk, I used a consultant, and when I applied for the High Court bench, I did. And the advantage of that was I saw the advantage of getting a third party to look at my form, and somebody who's experienced at looking at forms, and they basically added 10% in terms of the presentation so that you're putting forward your best case. And I thought that was useful. But you don't use a consultant, you can use a colleague, you can use a friend, just to look at it and say, and I've read many forms for other people saying, what are you saying? So it's a judgment call, but there are some very, the consultants are working with the material they've got there, that they do help. And that was my approach. It's not everybody does, you don't need to, but I did.
That's
Can
really
I
helpful,
suggest,
thank you.
they're not cheap, these consultants, and especially the ones that have a very good track record. A slightly cheaper alternative would be what I did, and it's on the premise that when it comes to the interview part of the selection day, so not the questioning on the scenario or the role playing, but the interview part, which is really about your form and your competencies and your evidence, it's fairly obvious, he says, with a few years of experience, what you're going to be asked. Please give me an example of where you've shown leadership skills, or you've worked as a team in a team, for example, or you've led a team. And you'll know all that material because you'll have completed your form, and as Amanda suggested, you'll have updated it in preparation for selection day. A cheaper alternative to what Amanda did was what I did, which was to get someone who knows you very well, a non-lawyer, to interview you.
Yeah.
And as painful as it is, and it is painful, record it. And then you have the joy of watching the recording back, and your close family, friend, ally, my wife in my case, could critique it and say, why are you putting on a strange voice? why have I never heard you speak in this way before? Why are you sitting strangely? And honestly, it's painful, it's excruciating. It was for her as well as for me. But I would rather, and I thank her most days for this, I would rather she had done that with me on what was 7 occasions before the real interview, than that being my interview for the job. Yeah. And they won't know that I'm not speaking properly because, or I'm putting on a fake voice or whatever, or my mannerisms are different, because they don't know who I am. All they'll be seeing is someone who's a bit cardboard, who's trying to play the role of a judge and isn't being true to themselves, and probably making a complete hash of it. So if you have someone who is prepared to do that for you, and you have the courage to watch the recordings back and take on the critique constructively, then I'd suggest you do that.
Well, I think that's brilliant advice, Vic, because the point is you have to be yourself in interview. But it is the interviews, it's difficult giving the examples, but you've actually just got to drill yourself into giving your best evidence on the day. And if somebody tells you, as in my case, that I look out the window when I'm thinking and don't look at people, you need to know that, because you've got to look at them. But as Michelle said at the start, you've got to be yourself, because you've got to be true to yourself, and you've got, you can't be somebody else. You have to be yourself. So that's great advice, but it's far better to go through that at home than stuffing it up on the day.
Definitely. Last question, I think, is do the tests appear on the JAC website? I don't believe they do.
Ask Emma that.
There is a mock test on the website, which is the initial SIFT test. I think that they use for DDJ recorder type processes, and it's multiple choice, and it requires you to give the least appropriate and most appropriate answers. And I will make a confession. Amanda knows this.
You don't have to tell us your scores.
Well, I think it would be obvious from the way I'm going to tell the story. I only realised this test was on the website last week. And my husband and I did the test together, and we worked out between us, we've got 18 years of salaried experience, lots more years of fee paid experience before that. Our combined effort was such that we don't believe we'd have got through.
but the serious point on that is, for those of you who are looking, do have a look at those practice tests, because it's very helpful in showing you what the tests are. Now, those are the tests for the moment. You may hear anecdotes about them, but do have a look and do understand it. And I don't know what other tests there are there, but when I did the record exam, you could get the mock test, and I made myself sit them. And again, a bit like Vic being videoed, it wasn't the most interesting way to spend a Saturday evening or whenever I did it. But the fact I took the trouble to make myself do it meant that I was in the right mindset when I did the exams itself. But do look at those examples, because they will help you in showing the way they formulate them. And that's the way the process is at the moment.
I think there's something on the JAC website called "Are You Ready?"
Yeah.
And that's it's like a questionnaire, isn't it?
Yeah.
So to give you an idea as to whether you're ready to apply for judicial office.
I mean, I have to say I'm slightly sceptical about the test on the website. If that is genuinely what the JSE are using, it's not at all clear. And our combined view was that most of the scenarios were ones where if it was happening in real life, you'd ask one or two more questions to ascertain the true factual position, and that would inform your answer. But I think that the thing to take away is do not be put off if you get bounced on trying to complete one of these tests in a competition. It is no reflection on your ability. I think the JAC selection test, in my experience, and I've done the DDJ, DJ recorder, civil CJ and DCJ, is that the JSE do place a lot of emphasis on working quickly. So you quite often get a lot of material and you've got to work at speed, and you're often in a position where you're having to make decisions far more quickly than you actually would in real life sitting as judge. So be prepared to work at speed and have a lot of material to read.
And if there's a time frame, you've got to make sure you get the material in the time frame. So if there's a test to be completed with questions, you've got to finish it.
Yeah.
So as Emma says, you just got to move on and finish the test. Or if you're in some form of situational test, which has got a time frame with a decision, it's not so much the decision, it's your ability to make a decision and give the reasons, which is what they're interested in.
Yeah, no, absolutely. And so that's always been my experience in relation to both role play scenarios in the DDJ and recorder and the situational questioning. You almost always have to give some form of judgment, and they're not so much interested in the decision, but the fact that you can give a judgment within an appropriate period of time and give reasons as to why you've come to the decision that you have.
Yeah.
Right, we're almost close to time. I've put in some links, as has Vic. The links are to the Equal Treatment and Diversity Bench book. That's the first one. Then the JAC guidance on the application process. Vic's helpfully put in the link for the Judicial Education Programme, and then finally I've put in the link for the Judicial Mentoring Scheme. So thank you everyone for joining us. I hope you found it useful, but also mainly thank you to Birmingham Law Society for sorting out the admin for this, to our speakers who have given up their evenings, that have had long days in courts. We couldn't run these events without the support of the judiciary, and I'm incredibly grateful. So thank you everyone. Any questions, you can always get hold of me from the Number 5 website. Yes, sorry.
Can I just make one point before we sign off,
Yeah.
which I meant earlier? Michelle, thank you very much for running a survey through the Midland Circuit in relation to judicial appointments and for your report. What I would say to anybody is that if they've got any further thoughts on that, then do contact Michelle, because Michelle has prepared a very valuable paper in relation to judicial appointment and the recruitment process, which is very useful to have, and I'm grateful to her for the work she's done in it. But if anybody didn't participate in her survey but has got any thoughts which she'd be willing to share, or you have anything which comes up in the future, do contact Michelle so she's got that evidence, because we as judges are very conscious of that there is not enough judges in some areas, and what can be done to improve on that recruitment process. So the things you think we should know about, do contact Michelle, and so she can pass that on. Thank you very much.
Except next Friday, when I'm going to Florida and I won't be here or answering emails for 2 weeks. Just telling you.
You can wait till after that.
And likewise, I repeat the offer I made earlier. If people want some support from a salaried judge, please feel free to contact either me or Sybil. Michelle, I think you can provide our email addresses to anybody who wants to some assistance.
I will do that again. Yeah. That's really kind.
It's like Vic is making the same offer.
Yeah, fantastic. Thank you, everyone. I'm just incredibly grateful. Well, that's been hopefully a really useful seminar for everyone. It's nice to see so many different aspects and career paths to the judiciary. So thank you for joining us, and we shall be organising further events like this in the future. So make sure you're on the Law Society or the Midland Circuit mailing list, and we'll keep you updated. But as for now, good evening, everyone. Go and enjoy Only Connect. Thanks all. Bye-bye.
Thanks,
Bye.
Michelle.